is dated 2/9/2024. Would you all ask this?
Yes.
ಕರ್ನಾಟಕ ಲೋಕ ಸೇವಾ ಆಯೋಗದಿಂದ 23-24ನೇ ಸಾಲಿನ 384 ಗೆಸ್ಟೆಡ್ ಪ್ರೊಬೇಷನರ್ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿಗಾಗಿ 27/8/24 ನಡೆಸಲಾದ ಪೂರ್ವಭಾವಿ ಪರೀಕ್ಷೆಗೆ ಸುಮಾರು 1,30,885 ಅಭ್ಯರ್ಥಿಗಳು ಹಾಜರಾಗಿದ್ದಾರೆ. ಇವರ ಪೈಕಿ ಶೇಕಡ 50ಕ್ಕಿಂತ ಹೆಚ್ಚು ಅಭ್ಯರ್ಥಿಗಳು ಕನ್ನಡ ಮಾಧ್ಯಮದಲ್ಲಿ ಪರೀಕ್ಷೆಯನ್ನು ತೆಗೆದುಕೊಂಡಿದ್ದು ಸುಮಾರು 58 ಪ್ರಶ್ನೆಗಳು ತಪ್ಪಾಗಿ ಕನ್ನಡ ಭಾಷಾಂತರವಾಗಿದೆ ಎಂದು ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಗಮನಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಇದರ ಬಗ್ಗೆ ಬಾಧಿತ ಅಭ್ಯರ್ಥಿಗಳು ಈ ದಿನ ಫ್ರೀಡಂ ಪಾರ್ಕ್ನಲ್ಲಿ ಶ್ರವಣಿಸಿದರು. ರಾಜ್ಯದ ಕೆಪಿಎಸ್ಸಿ ನಡೆಸುವ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕನ್ನಡ ಭಾಷಾಂತರ ಸರಿಯಾಗಿ ಆಗದಿರುವುದು ಅತ್ಯಂತ ವಿಷಾದನೀಯ ಸಂಗತಿ. ಈ ಬಗ್ಗೆ ಆಯೋಗದ ಕಾರ್ಯದರ್ಶಿ ಇದ್ದಾಗ ಭಾಷಾಂತರ ಇಲಾಖೆಯಿಂದ ಕೆಲವು ಭಾಷಾಂತರಕಾರ ಸೇವೆಯನ್ನು ಪಡೆಯಲಾಗುತ್ತಿದ್ದು, ಜೊತೆಗೆ ಕೆಲವು ಕನ್ನಡ ಪರಿಣಿತರಿಗೆ ಸದರಿ ಭಾಷಾಂತರ ಕೆಲಸವನ್ನು ವಹಿಸಲಾಗುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಈಗಾಗಲೇ ಮಾಡಿರುವ ಭಾಷಾಂತರ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆಯನ್ನು ಸಂಬಂಧಪಟ್ಟ ಆಂಗ್ಲ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ತಯಾರಿಸಲು ನೋಡದೇ ಇರುವುದರಿಂದ ಹಾಗೂ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ಸೋರಿಕೆ ಆಗುವ ಭಯದಿಂದ ಯಾವುದೇ ಅಧಿಕಾರಿಯನ್ನು ಉಸ್ತುವಾರಿಯಾಗಿ ನೇಮಿಸದಿರುವುದು ನೇರವಾಗಿ ಜವಾಬ್ದಾರಿ ಕಂಟ್ರೋಲ್ ಆಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮೇಲೆ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿ ಆದೇಶದಂತೆ ತಪ್ಪಿತಸ್ಥರ ಬಗ್ಗೆ ಒಂದು ವರದಿಯನ್ನು ಸೂಚಿಸಿದ್ದು, ಅದರಂತೆ ಇದರ ಬದಲಾಗಿ ಬೇರೆ ವ್ಯವಸ್ಥೆಯನ್ನು ಸಿಯಾಸು ಇಲಾಖೆಯಿಂದ ಮಾಡಲಾಗುವುದು. ಮುಂದಿನ 2 ತಿಂಗಳಲ್ಲಿ ಭಾನುವಾರದಂದು ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗದಿಂದ ಮರುಪರೀಕ್ಷೆ ನಡೆಸಲು ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಆದೇಶಿಸಿದ್ದಾರೆ. ಈ ಬಗ್ಗೆ ಅನುಪಾಲನಾ ವರದಿಯನ್ನು ಕಳುಹಿಸಲು ಕೋರಿದೆ. This was the direction. Followed that mirror page 146 may kindly be seen. ಇಪ್ಪತ್ಮೂರು 24ನೇ ಸಾಲಿನ ಗೆಸ್ಟೆಡ್ ಪ್ರೊಬೇಷನರ್ಸ್ ಗ್ರೂಪ್ ಎ ಮತ್ತು ಗ್ರೂಪ್ ಗಳಿಂದ ಒಟ್ಟು 384 ಹುದ್ದೆಗಳ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪೂರ್ವಭಾವಿ ಮರುಪರೀಕ್ಷೆಯನ್ನು 29/12/24 ನಡೆಸಲು ನಿಗದಿಪಡಿಸಿ ತಿದ್ದುಪಡಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಲಾಗಿದ್ದು, ಸದರಿ ಪರೀಕ್ಷೆಗೆ ಎಲ್ಲ ಅಭ್ಯರ್ಥಿಗಳಿಗೂ ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿರುತ್ತದೆ. Based on that, my lord, the examinations are scheduled, rescheduled examinations have taken place. Very self preliminary examination have taken place. This time, my lord, it was noticed there are about 79 questions which in Kannada are improperly, incorrectly, and without providing any meaning translated. This was the complaint. But if there was the matter at the stage that KPSC intended to publish the result of preliminary examination, they wanted to proceed main examination. At that stage, we have approached it disorderly. Your Lordship is aware of the first date of hearing on 2025. Your Lordship made a note of all these facts and passed an interim order directing not to prosecute the matter. Then matter was listed on 30th January. On that day, some modifications have taken place. Then taking advantage of that matter, they notified the timetable for main examination, as well as they have also informed to lodge in the application for the main exam. Again, some orders have been passed. Now later order, so far as issuing and proceeding with the timetable is concerned, your Lordship stepped in again. This indicates my submission to Lordship is it is now, it is too much noise on the floor also. I think your Lordship is aware, it is consistently notified in all the newspapers, and even it is telecasted at the open all media inside the house what happened on that day. The opposition leader was raised this issue. Honorable Chief Minister taken 2 days to answer. After second day, Honorable Chief Minister before and present before the floor, and he said, yes, there is serious critical illegalities or infrastructure problems are available so far as competitive examination and method of conducting competitive examination is concerned. Even a committee is constituted to suggest certain amendments to 1959 rules. A committee is constituted, it was notified on the floor. But issue relating to fate of this examination is concerned, it is yet to take a decision. Therefore, we are insisting state government has to come up with a stand. Whether are they sailing with PSC or they wanted to take a different stand. Suppose if, my lord, if the state says, yes, there is a mistake in all these things, we wanted to take an independent decision, then Public Service Commission, senior counsel would not, or any advocate and government advocate are not entitled to appear for the government and the KPSC together. Because there is a conflicting interest. They have to take a stand. Ultimately, your lordship said, government is not doing something in that. Government alone has to do that because they are appointing authority. Government, KPSC is only an examining body.
Government is morally supporting the KPSC
So,
without filing any reply statement, without taking any specific defense. Yes,
what is no error has taken place, we are sailing with PSC, we will welcome it. We will welcome it. We are not here to direct the government to do this or that. Who are you? We are not there. Let they can come up with a stand, whether they are sailing with or no mistake or everything is correct. But unfortunately,
now age is appearing for the appears that the
Lords, government, in so far as government, Lords, there is no conflict of interest. There was conflict of interest. No, my learned friend, my learned friend, with all due respect, he cannot, my lords, this matter is set on for final hearing. Now, my lords, the entire candidacy on the last date of hearing when senior advocate was not there, my lords, in fact, pointed out you are trying to drag the matter. Matter is set on for final hearing with the existing pleading. Let them argue the matter for final hearing. With all due respect, my lord, these dilatory tactics. It is a dilatory tactics. Now he wants to make.
The senior counsel is the affiliate for KPSC.
My lord, may I make this submission on the last?
Only based on the defense set out by the KPSC, we can decide the issue.
the best man to decide.
If they have
On what
decided
basis
not to fight
we
that,
will-
no, we are just asking you that you are saying that at the floor of the house, government has made certain.
Correct? Correct?
Committee has been established.
But that, is there any notification or something you have got?
No, let's take, how I can get a
Because
notification.
you are mentioning.
I am relying upon the
wanted
newspapers
to
and
know.
the TV.
I just
I
wanted to know.
personally visited the telecast on the floor is concerned. Question was
only-
incident
whether they are any-
So whether you have a copy or anything of that. If not there, we'll ask them. No issue. No issue.
Lords,
I
in fact,
wanted to know that whether you have got a copy of that which you
But
said.
my question is very, very simple to the government. Government can say, no, we are not going to file objections.
It's okay.
Or we are supporting PSC. They can put it in 4 lines by way of memo. Because it is a very good equipment for us to proceed further. It's a
Even
very
if
good
they choose
equipment
not
for
to
us.
reply, it will be noted like that. If they choose not to reply. That is.
They can say so. What is the hesitation for them?
no. Respondents have, my lords, respondents have a right not to defend a case. Let them not, my lords, let them argue their case. Kindly note, my lords, may I also bring one fact to the
They
notice?
don't want to say the
Let
matter.
me record it.
Can't give any direction to the state government to. You
File
have
a
to,
reply.
you have to file reply.
We have
Now-
given them
Now
time.
I insisted, government should have to take a stand in this matter. Because of certain reasons. I said the reasons. May kindly
They will
record.
take a decision, the government will take a decision in the floor of the house. When the matter is seized before the floor of the house, when it is the subject matter of the house, they can't take a different stand in different forum. Anta ಬಹುಶಃ ಅದಕ್ಕಾಗಿ because of
Lords, not only that, last time what had happened was one submission, sir, one submission.
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅನ್ನೋ ಮುಖ್ಯ ಅಲ್ಲ.
ನನ್ನ
ಅವ್ರು
decision-
ಏನಾದ್ರು ಸ್ವಲ್ಪ ಹೇಳ್ಬೇಕು ಮುಖ್ಯ. ಯಾಕೆ ಅಂತೀನಿ ಅಂದ್ರೆ
ನಿಮ್ಮದು ಕರೆಕ್ಟ್ ನಿಮ್ಮದು ಕರೆಕ್ಟ್
They are no reply to strengthen your case.
ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಏನಾದ್ರು ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡ್ರು ಮತ್ತೆ ಗೌರ್ಮೆಂಟ್ ಇನ್ನೊಂದು decision ತಗೊಂಡು ಬಾರ್ ಆಗ್ಬಾರ್ದು ಅಂತ
It's a very, very tricky issue.
Milord, you are largely dealing with a competitive examination conducting by a reputed constitutional agency which decide the fate of the graduates and double graduates. Therefore, they cannot rightly come and say,
We are
"See, we
deciding,
are dealing with 7th standard of public
whatever it may be, the
examination."
KPSC is the contesting the application.
They-
They have filed reply statement, they are contesting the case. We decide it on the basis of the available material.
Complaint as
Can't insist or directly, can't insist the government
say,
to take a specific stand in this application. Matter is seized before the house, floor of the house.
My lords, not only that, may I just make one submission? In the last round of litigation, when, my lords, there was a chief Tippani, my lords, from the chief secretary, and thereafter there was a tweet from the chief minister with regard to re-exam. Matter, my lords, was challenged, my lords, before the Dharwad High Court. Their contention was KPSC is a constitutional body. KPSC has to take an independent decision. It cannot abdicate its decision-making process, my lords, for the government. So that was the contention, and initially there was a stay. Thereafter, my lords, we were able to go before the Dharwad bench. I argued the matter. We were able to show that the information was furnished by the before a decision was taken for re-examination. It is the commission which took the decision on the basis of a report of the subject matter. So at the end of the day, my lords, we are a constitutional authority.
Even though the government is appointing authority, when the matter has been assigned to the KPSC for selection,
that's
they
what.
have to conduct the government, scope of the government is very limited to interfere in the selection.
Government can write a letter to us. Government cannot direct us.
And
I would.
of KPSC, that government has nothing to do with this matter.
No, let them argue the matter, my lord. Let them.
Whether to take a re-exam or not, that is.
Issue ಏನಿದೆ?
ಹೇಳ್ತಾ ಇದ್ದಾರಲ್ವಾ ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡಿ ನಾನು
Argument ಮಾಡಿ sir.
Assist the court to answer to the queries that they have given such either.
Let them argue the matter. My lords, otherwise, my lords may vacate the stay. My lords may vacate the stay. They don't want to argue the matter. Let them argue the matter. Let government.
It's not a question of arguing that. Ultimately, it's recruitment to group A and B, appointing authorities by the government. Government can't say, I will not take a stand in such an important matter. Let whatever happen, I will see thereafter. But when your lordships have called upon the government to take a stand, can the government say,
Can we insist government to
I'm not
take a
saying your
stand?
lordship, I'm not saying
You
your
are
lordship.
making us say that,
I'm not insisting your
that you ask government to take a stand. How can we do
I'm
that?
not. That's not a submission.
We are not
submission
a
is
executive appellate, no.
please there
See, what is your contention
minute,
here?
madam.
You argue your contention.
1 minute Vinod.
Your contention is re-exam. Is your contention
Take it,
re-exam?
take it.
Then you argue on that.
Take it from us, take it from us. We are not running away to argue the matter. We are prepared to argue the matter.
Yes,
Please argue, sir.
We have been waiting since morning. to know
Subject
that.
to my lord, your lordships now, something is transferred from our end, something is transferred from their end. Either your lordship wanted to insist them to file a take a stand, let they can. Otherwise, record our submission and say, leave it to that extent. Then we will carry the matter wherever it goes.
Lords, my submission in response to that is
Why
simple.
not?
Let them argue the matter by the time the turn of the government.
You have to
answer.
the court,
Let them argue.
you have to establish your case.
Then I will be able to.
Just you submit your arguments and establish your case where they have committed mistake. If they have committed mistake, we give an opportunity to them to clarify it. If by way of argument, let they clarify it. Let they convince it. If they have failed to convince it, we allow the application. If they have succeeded in convincing, we will dismiss the application.
Can I
Stay vacate ಮಾಡಿ ಸ್ವಾಮಿ. Unnecessary they are dragging on the matter.
Can I submit?
Yes, you can.
Record my submission. Say it is
Hanging.
rejected.
Nodi,
Nodi.
See,
you are the senior counsel. You are the senior counsel. You can argue the arguments. What is to be recorded? What is? Don't dictate to the court how to don't dictate to the court. It is only it is request that don't dictate to do like this, court do like this, give direction like this by way of interim order. You can't only you have sought for 3 reliefs, sir. How else, sir?
ask your.
You are seeking 3 reliefs. Whether you are entitled for these reliefs or not. Also, you have filed an interim application by interim. You are sought for interim relief. We have considered it. whether you are entitled for interim review or not, we have already taken a decision. Now we have to take decision only on the 3 prayers.
One development.
Except these prayers, you can't, whether you are, if you allow, you have proved it, you are entitled it, certainly we allow it.
1 minute.
And in the meantime,
Last
before
suggestion.
deciding these 3 issues,
Last
prayers,
suggestion.
we can't direct them to do so and so, do give, attend so and so.
But from the bar,
On
we
the
are
oral
examining.
submission, we will not give any direction to the government.
It need not be.
I think I can.
Sometimes
Only,
government chooses
what is
one
your
over the
case?
other.
I know.
What are your prayers? Submit on this. If you are entitled, certainly will come to your rescue, otherwise no.
What has been transferred on 30th January? On 30th January.
We are not conducting a meeting. We are arguing the case. You are arguing the case. We are deciding the case. Don't, it is not a forum to discuss as a round table. Can't take a decision by way of resolution.
I'm saying.
Don't allow the court to pass such a resolution by way of interim orders.
And my lords, modus operandi is a deliberate tactic. We can make out that.
January 2025, your lordship's recorded a proceedings of the government dated 29/1/2025.
Okay, we are referred it to
Correct.
grant
that
a
day,
interim
madam,
order,
on
interim
that day-
direction, interim order.
No, it is not interim order. 29th January 2035 proceedings.
To
It's a
support
taken-
our views, to support our interim order, we are referred this certain documents produced by, but it is our duty to refer it.
What happened on the day is, I referred to a government proceeding dated 29/1/2025. It was a meeting conducted by the Honorable Chief Secretary of the State in presence of the KPSC Secretary. Where the issue.
You can take advantage of that document. It is best document to take advantage. What is the government stand? We can, you can ascertain from the said resolution only.
After that.
ಆಮೇಲೆ ನಮ್ದು ರಿಪ್ಲೈ ಆದ್ಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಬರೋಷ್ಟ್ರೊಳಗೆ ಅವ್ರು ಹೇಳ್ತಾರೆ.
After that, things have moved. After that, they have issued key answers on 3rd. Then they have done a provisional thing on 10th. And then they have issued also our notification for the timetable. Then we told them not to take up anything. Then we also allowed them to take the applications. And they have
But
given a
on
further
that-
date. Now see,
could
as
recollect
a
memory.
judicial member said, let us
I-
concentrate on these.
Madam,
three points.
I could recollect the memory. From my memory, I read this submission. After seeing this 29/1/2025 proceedings in the chamber of the Honorable Chief Secretary, your lordship specifically asked the government, what steps you have been taken pursuant to this? Your lordship may tell you.
After that,
select-
we-
Posing
no.
of question.
We have questioned, it is up to them whether they choose to
Conclusion.
reply or not, no. In
That is
many
not our
cases, the
conclusion.
government
Only
chooses
to
not to
get
reply.
clarification, we put.
Every day we see in many cases, this may be an important case, but for us, every case is important. We see in many cases, government chooses not to reply.
Not in a normal
So let us
situation.
see, let us.
Madam, every day.
First
every
you make
day.
your argument, no, then
Madam,
we'll see what they
every
want.
day we are arguing of 5 to 6 matters. In all the 6 matters, we are not raising this kind of objections. Where there is a serious gravity of the subject is involved, state importance is very much required.
It is
I
up to us
notice
to
the
see.
necessity of the.
You are not even.
Madam, I am
started.
not asking them to file a counter.
I am sorry to say this, he is shying away from arguing the matter.
It's not going
He is shying
anywhere.
from arguing the matter, sir. Please argue.
It should go somewhere. No, your contention should lead us to something, no? Whether we want them, we have to give them some time.
You, sir, you can argue on that point. Yes, because they have not taken a specific defense. They are not they are not supporting either the, so you, in spite of the chief minister notice, they are not government, you can take any, if there is any substance, your arguments will pass we can pass adverse remarks against them while passing final order.
My lords, one submission on the last date, rejoinder ಆಗ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ನೋಡಿದ್ರೆ ಯಾವಾಗ ಬರುತ್ತೆ ಅಂದ್ರೆ ನಾವು ಅವರಿಗೆ ಕರಿಬೇಕು. ನಾವು ಕರೆದಿದ್ದನ್ನ ತಾವು ಆರ್ಟಿಫಿಷಿಯಲ್ ರೆಫರ್ ಮಾಡಿ ಅದನ್ನ ನಾವು ಕಂಪ್ಲೇಂಟ್
Evidence Act, strict Evidence Act is not applicable in the criminal cases. Evidence Act strict, it is not necessary to follow the Evidence Act in the this proceedings.
My lords, they are only trying to not argue the
You arguments
last date ಅಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ರು.
It will argue the matter, no issue. But how much that statement is important for us, I only know because I'm appearing for 26 applicants. It is not for the KPSC to decide. I have a, if I not decided, then who else can decide? Who else can decide?
ನೀವು ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ತೀರಾ? ಇಲ್ಲ.
My lords, in so far as the state is concerned,
ಅದಲ್ಲ ಟೈಮ್ ಪ್ರಶ್ನೆ ಅಲ್ಲ. ನೀವು ಏನೋ ಸ್ಪೆಸಿಫಿಕ್ ಡಿಫೆನ್ಸ್ ತಗೊಳಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅದನ್ನ
Argument ಆದ್ಮೇಲೆ.
my lords, the state will reply when its turn comes. Let them not, my lords, put the
Now,
state
and
on
that-
mat.
because ಅವ್ರು ಒಂದು ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದರೆ whether you are ready to file reply statement and take any specific evidence or
Argue the
or
matter.
otherwise orally will submit it. Our oral arguments may be taken as our reply statement. You can
ಅಲ್ಲ,
submit
we'll argue the matter today, but
Lord.
state can't file its reply later. We
My
are
lords, in
making
fact,
very clear.
they make one submission.
After our arguments, they can't
You
file.
can't take a specific defense.
We can't.
Even after,
They can't file rejoinder.
See,
But once
they can't-
arguments are complete, they can't file, take new defense.
you are also
Depends on
putting.
the opportunity to you. And if they find
Cases you all are putting rejoinder after statement of
Like
objection.
after arguments, there's no stage. Hearing means after
ಈಗ
pleading.
ಬಿಡಿ ಇದು ಪ್ರೊಸೀಜರ್ ಈಗ whatever it may be ಈಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅವರೇ it is now it is for final argument. It is already it is presumption that all the pleadings has been completed. Now it is for argument.
Yes.
Already you have begun your arguments.
Correct.
You have partly argued the matter.
Yes.
You continue it.
Yes.
My case is very simple.
Hmm.
There was an examination of preliminary examination for the purpose of
Well,
recruitment the post of gesture provisional class A and B. That was the revision of the second examination was culminated on 28th December. 24th December. On that time, my lord, the rules itself permits and the examination instructions also say Kannada answers could also be permissible to be written. And while filing the applications, we have filled up, we are intending to answer Kannada medium or English medium, that is very much available there. Then my lord, the method of preparing the question paper is questions for English medium and Kannada medium are one and the same. There would be no difference at all. Then my lord, English questions. We have produced a question paper. If you are looking to that, there would not be any ambiguity for the candidates who are taken to answer the questions in English medium answers. Then so far as Kannada medium people is concerned, translated have been provided in par with the, it should be in par with the English question, terms under the questions. Then my lord, the examination have taken place. What difficulty Kannada medium candidates visited on the date of examination was explained to media as well as the government, including the Public Service Commission. Then my lord, of course, we anticipating a certain response. It was not immediately, therefore we thought of that. Keeping quiet, awaiting any decision by the government, because government will always be lethargic. Therefore, we approached this honorable tribunal. Well, in our applications, we have pleaded this. This certain question, which is translated from English to Kannada, which is not giving any meaning at all. To show that
You are referred some translated document.
Take
right?
this copy.
This is also in the, just a small question.
What
The
was it?
application is dated 27/1/25. So in the re-exam also same problem happened?
Yeah, that's our complaint.
We are confining our submission only to the re-exam.
Re-exam.
Examination. Only apart from it, you have last time you have produced the actual meaning translated
Yes.
Google
then to go and their translation.
Merit one compendium we are placed on record.
Last time we put it.
Merit one compendium we placed on record.
Compare
That
it
was dated 28/12/2025.
page number.
Page two, it is a tabular form, it is same, it is there.
By way of a separate
Separate
memo dated 28.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಕಾಯ್ದೆ ಇಲ್ಲಿ ಕಾಪಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಏನ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ. It is a part of the record. It was filed on 25th January.
But this memo is not served on.
ಇಲ್ಲ 28ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡು ಕೋರ್ಟ್ ಅಂದಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಫೈಲ್ಡ್ ಇನ್ ಓಪನ್ ಕೋರ್ಟ್ ಅಂತ ನೋಡಿ.
But it has not been served on.
ಇಲ್ಲ ಅವತ್ತೇ ನೀವು ರೇಜ್ ಮಾಡಬೇಕಾಗಿತ್ತು.
I get a copy.
ಓಕೆ ತಕೊಂಡ್ ಮಾಡಿ ಈಗ ಸುಮ್ಮನೆ ಅದನ್ನ ಟೆಕ್ನಿಕಲಿ ಹೋಗ್ಬೇಕು.
I very near to the question I wanted to raise now. Very near to the question which I have raised. In which method we have earmarked according to our full knowledge, not to the extent of intellectual capacity of a public service commission expert. According to us, these questions which is translated appear to be incorrect. Appears to be incorrect. Certain questions we have underlined. It gives no meaning on the first day itself. Your lordship put a question to be clearly. So for a set of first question is concerned, your lordship may kindly go to page 3 of memo. It's a 97th number question. ಭಾರತದಲ್ಲಿನ ಕಾಯಿಕ ಪುನರಂ ಅವರ ಲೋಕನ ವಿಮರ್ಶೆ ಅಧಿಕಾರವು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದೊಂದಿಗೆ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯವು ಹೊಂದಿದೆ. ಇದು ಕನ್ನಡ ಟ್ರಾನ್ಸ್ಲೇಷನ್. ಇಂಗ್ಲಿಷ್ ಏನಂದ್ರೆ power of judicial review in India is entered by the Supreme Court as well as the High Court. This is the translation. ಇಂಥದ್ದು ಸಾಮಾನ್ಯ ಮನುಷ್ಯ ನನ್ನಂತಾನು ಅಜ್ಞಾನಿ ಒಂದು 50-25 ಹುಡುಕ್ಬೋದು. ಅಲ್ಲ 25 ಹುಡುಕ್ಬೋದು. ನಾನು
ಸಾಮಾನ್ಯ ಮನುಷ್ಯ ಅಷ್ಟ ಸಾಕು.
ಫೈಂಡ್ ಔಟ್ 25. ನಾವು ಪಟ್ಟಿರೋ 78ರೊಳಗೆ 40 ಅವ್ರದೇ ಸರಿ ಇರ್ಬೋದು. 38% are incorrect translation. Now they have stated prima facie this is our case. But what would be the stand of the KPSC then? Let's kindly see their counter for a moment. Have they denied that fact or not? Have they denied that fact or not? Let's kindly see their counter for a moment.
ಇದನ್ನ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಬೇಕು. ಏನ್ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ರೆ ಏನಾಗ್ತದೆ ಬಹುಶಃ ಇದು ಬರ್ಲಿಕ್ಕಿಲ್ಲ ಒರಿಜಿನಲ್ ಇದು. The power of the judicial review in India is enjoyed by the Supreme Court as well as High Court.
ಇವಾಗ BA ಒಳಗೆ ಪೊಲಿಟಿಕಲ್ ಸೈನ್ಸ್ ತಗೊಂಡು ಓದೋನಿಗೂ
ಭಾರತದಲ್ಲಿ
ಲಾದೊಳಗೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಲಾ ಓದೋನಿಗೂ ವ್ಯತ್ಯಾಸ
ಗೊತ್ತಿಲ್ಲ. ಇದು
ನಾನು ಇಂಗ್ಲಿಷ್ ಓದ್ಕೊಳ್ಬೇಕಾ ಕನ್ನಡ ಕೈತೇನೆ ಆನ್ಸರ್. BA ಓದಿರೋದು ಮಾಡಕ್ಕಾಗುತ್ತೆ ಅಥವಾ BSc ನಾವು ಹಳ್ಳಿ ಹುಡುಗ ಏನ್ ಮಾಡ್ತಾನೆ ಕನ್ನಡದಲ್ಲಿ ಆನ್ಸರ್ ಬರೆಯೋ ಸರಿ ಇರ್ಬೋದು, ಈಸಿ ಇರ್ಬೋದು. ನಾನು ಅದಕ್ಕೆ ಕನ್ನಡದಲ್ಲೇ ಬರೀತೀನಿ ಅಂತ ಹೋದ್ರೆ ಈ ಪ್ರಶ್ನೆ ಒಬ್ಬ BSc ಕ್ಯಾಂಡಿಡೇಟ್ ಇದ್ರ ಉತ್ತರ ಇದೇ ಇರ್ಬೋದು ಅಂತ ಇಮ್ಯಾಜಿನ್ ಮಾಡಕ್ಕಾಗುತ್ತಾ? ಆಯ್ತು, ಇದು ಬಿಟ್ಬಿಡೋಣ. ಇವಾಗ ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ನಾವೊಂದು ಪ್ರೈಮಾ ಫೇಶಿಯ ಮೆಟೀರಿಯಲ್ ಕೊಟ್ವಿ, ಇದು ತಪ್ಪಿದೆ ಅಂತ ಹೇಳಿದ್ವಿ. ಇದಕ್ಕೆ ಅವ್ರ ಆನ್ಸರ್ ಏನಿರ್ಬೇಕು? ಇದು ಒಂದು ಲೇಮ್ ಎಕ್ಸ್ಕ್ಯೂಸ್. ಸುಮ್ಮನೆ ಒಂದು ನಾಮಕಾವಸ್ಥೆ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ, ಇದರೊಳಗಂತ ಯಾವ ಅಂಶಗಳು ಇಲ್ವಾ? ನಾವು ಮಾಡಿರುವಂತ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಅಟ್ಲೀಸ್ಟ್
ಒಂದಕ್ಕೆ
Just a small question here. Whether all these clarification and the problems are brought to the notice of controller of examination also?
They are not controller of examination. There is no such.
No, but there is always a question. ಇದು ಇರ್ತದೆ.
But you could be able to come.
If there is any key answer ನಲ್ಲಿ ಅಥವಾ ಏನಾದ್ರೂ problem ಇದ್ರೆ you can inform.
The answer, it is a post examination
So I just
situation.
want to know this, whether this complaint was
See,
made to
whether
the
such system
KPSC.
is there or not.
Objections were filed. We filed our objections.
They admitted there are 161
Correct.
objections have been
We just
received to
wanted to
them.
know this.
Only.
ಇದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ತಾವು ನಮ್ಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ, you have given no, this is the ತಪ್ಪಿದೆ and this is the corrected version.
ಹಾಗಿದ್ದೀವಿ ಅದನ್ನ
ಸರಿಯಾಗಿ
ಅದನ್ನ
ಬೇಕಾದ ಪ್ರಶ್ನೆ.
ನಾವು ಇದೇ ತರ ಇವತ್ತೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
This have you submitted to KPSC?
ಇಂತಿಂತ ಪ್ರಶ್ನೆಗಳು ತಪ್ಪಾಗಿ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಆಗಿದೆ, ಇಂತಿಂತ ತಪ್ಪುಗಳಾಗಿದೆ, ಇದು ನಮಗೆ ಪ್ರಿಜುಡಿಸ್ ಆಗಿದೆ, ನಮ್ಮ ವೆರಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಪರ್ಪಸ್ ನಮಗೆ ಡಿಫೀಟ್ ಆಗಿದೆ, ನಿಮಗೆ ಸರ್ವಿಸ್ ಆಗಿರ್ಬೋದು, ನಮಗೆ ಡಿಫೀಟ್ ಆಗಿದೆ ಅಂತಲೇ ನಾವು ಕೊಡ್ತೀವಿ. ಇದು ನಾವು ಇವರಿಗೆ ಅಷ್ಟೇ
Is there any
ಕೊಟ್ಟಿಲ್ಲ.
date for that? Any date is there? When you submitted this application?
Yes.
We have
So far as I am concerned, my objection
our
21/1/2025. ಒಬ್ರು ನನ್ನ ಹತ್ರ ಇದೆ.
21.
21/1/2025. Memo ಕೊಟ್ಟಿರ್ತಾನೆ. I just keep it by that. Not. Just to show that objections are made.
Yes, it is, because that makes it that
Yes.
they were aware of it.
Correct.
We are now at a very crucial statement. Please, kindly take serious note of this. I'm very eager to answer this. Answer. At least my instructions from the advocate on record, they are also given this kind of representative of PSC on 22nd January 2025. We look at paragraph 5 of their counter. First three paragraphs, they refer to about all what is the subject matter and application, and I don't want to cover even of it. Paragraph 5 may can be written. Respondent Public Service Commission by the notification dated 26/2/2024 notified 384 vacant posts of guested professionals for recruitment in terms of so and so rules 1997. In pursuance of the said notification, preliminary examination was conducted on 27/8/2024. About 1,31,885 candidates participated. Following the exams held on so and so, 206 number of objections were received by the Public Service Commission from the candidates regarding correctness of translations in questions to Kannada language in both paper 1 and 2. It was also brought to the Commission's notice that several grievances specifically complaining of error having crept into the translation of English questions to Kannada language. First paper, second paper, papers of preliminary examination were received by the state government. The second respondent Public Service Commission, keeping in view of the magnitude of the objections and grievances, took a decision to conduct a re-examination. Notice for the date of re-examination as on 29/12/2024. Well, up to this they have admitted earlier. What is they specifically admitted is this language. Public Service Commission, keeping in view of the magnitude of the objections, grievances, took a decision to conduct a re-examination. Translation error is admitted by the Public Service Commission. It is a magnitude of objections and gratitude. What is that? Objections, grievances. It constitutes some degree of meaningful. Therefore, they conducted re-examination. Then go to the next statement. Paragraph B. Whether it refers to our pleading is concerned, is I wanted. Paragraph B. The provisional answer keys to the paper 1 and 2 of the preliminary examination conducted on 29/12/2024, released on 15/1/2025, simultaneously inviting objections from the candidate to be registered within 7 days from the date of the release of provisional answer keys. Copy of the notification of so and so all two on receipt of 1,710 numbers of objections to the provisional answer keys, including respect of such error, may have occurred in translation questions from English to Kannada language. Expert committee was set up to examine the correctness of the answer keys, which reference to the objections received, including that in relation to the error of translation. The KPSC constitutes a 12-subject expert committee. Each committee consists of 3 subject experts, having reaching the knowledge of both languages, Kannada and English. The expert committee having examined the answer keys and opined that in respect of 5 number of questions, translation to Kannada language and also technical aspects would also impact the candidate, it would not be possible to answer the question correctly. It was recommended by the expert committee that in respect of these 5 questions, grace must be awarded to all the candidates. Based upon expert committee report, answers key got revised and revision key answer dated 3/2/2025 published, followed by the publication result of the preliminary examination on 2010-2025. Is there any specific denial of the fact what the 78 answers appears to be incorrectly translated? That is not correct. Every question is correctly translated. Is it give such a meaning in the counter? Is it a denial of
According to them, only 5 questions, error was happened only in 5 questions.
Could it
Out
give
of-
that meaning exactly in respect of our feelings is concerned?
According to the applicants, there were
78,
something.
45. We qualified 78. At least in their counter, which 5 answers found to be error according to the educator. So after that, madam, what is further stand your office may kindly see me. Paragraph 6 may kindly be seen. It is most respectfully submitted that the applicants in the present case are not entitled to the relief claimed for the sole reason that they have failed to demonstrate as to how the recruitment source has to infringe in their right so as to warrant issuance of the prerogative direction to conduct a re-examination by cancelling the examination dated so and so. Next, madam, may kindly be seen. It is most respectfully submitted that case of the applicant is one improper translation of questions. Same cannot be a ground to hold that only the applicant suffered a disadvantage as against the other candidates who participated in the preliminary examination. A total number of so and so candidates in morning section and evening section so and so, then 5,704 candidates were declared to be successful and eligible to participate in the main examination. This is the stand. Then, madam, one more stand that they have taken is let me kindly go to page 5. The sentence commencing from it is not the case of the applicant in the present case that objections raised by them were not considered. The applicants in the present case have failed to plead or to demonstrate before the honorable tribunal as to how the action of the commission have resulted in so grave or large scale of consequence so as to mitigate the entire selection process. The applicants have failed to plead and demonstrate any material irregularity or patent illegality in the selection process. My lord, one more objection they have taken. It is of course, my lord, very this paragraph 9 may kindly be seen. The commission has notified inviting objection from all candidates in response to 1708 have registered their objections. Applicants in the present case have not placed any material record to show they have registered raised objection to key answer and non-consideration of objections, etc. What is our grievance, madam? Is there our grievance against key answer? We are not reached to the stage at all. Because on the day when 25/1/2025 applications were called, other side have appeared on 30th January. 30th January, they made a submission. We are appointing a committee, an expert committee wanted to submit a report. Your interim order in the nature that not to be precipitated, that order would come in the way of at least to appoint an expert committee, therefore modify that order. I hope I am true in making a correct statement before your lordship. On that day, it was not an issue, either in the T answer, or it is not an issue related to expert committee have already been appointed. There's clear submission on that day, even at the age of my 67, my memory appears to be not so unsound. And that day, this is a submission they placed on record saying that nature of interim order, directing not to precipitate the matter, would come in the way of appointing the experts also. And process of valuation, all these things will take more than a month together. Ultimately, we will have to negotiate with the government also. Therefore, we modify that interim order, instead of restricting the precipitation, certain extent, liberty be given to proceed with the matter, that liberty your lordship grants. Now, law is very clear, madam. I can cite one judgment of the Apex Court. Lord, this is the latest judgment of the Apex Court rendered on 14th June 2018. Let me kindly go to para 10. This court was dealing with a case relating to combined free medical tests. Admittedly, examination sector himself had provided a key answers, and there were no committee to moderate or verify the correctness of the key answers provided by the examiner. This court upheld the rule of the Allahabad High Court. Students have proved that key answers were wrong. Following the observations court made. Madam, this is very important. What is the burden of the applicant and others? We agree that key answers should be assumed to be correct unless it is proved to be wrong. And it should not be held to be wrong by an inferential process of reasoning or by a process of rationalization. It must be clearly demonstrated to be wrong, and it is to say it must be so reasonable body to none well reverse the particular subject with regard as a correct. Whereas my submission to lordship based on this principle is these quotations. Specifically, we have pleaded, these are all the questions. These questions are incorrectly translated. We codified about 78 out of 100 and 200 mark, whatever it may be. Out of it, now they come up with a stand saying that only 5 questions. Where is the material before me? Is there any material before? This is the expert committee. They convened a meeting. This is the subject they have analyzed. See, according to them, only 5 answers, 5 translations are incorrect. Why this hidden secret?
I think what they have done, they have only looked into the key question, key answers. They have not looked into the translation part.
Correct.
So because there is an ambiguity in the, you are saying there is an ambiguity in the questions itself. Because see, to my understanding, whatever they have submitted, KPSC has only a provision for asking for key questions. If there are key answers, if there is a problem, they're asking for, objections to that. There is no objection to about the question itself. You are raising the problem about the questions itself, that they are ambiguous, that Kannada translation is not correct. This is what you are raising.
No, my submission.
I don't think the expert committee has looked into that aspect at all.
Then what would be the ultimate?
No, I am asking you. Because they have
But I
submitted,
could not be able to answer that question because their counter refers to this.
I'm asking
But
KPSC.
except that there is no other method. But one question I would like to put it for myself. If I come up with a blank awareness in application saying that only there are 200 questions are given consisting of 200 paper, 200 marks. There are 2 question papers are there. Out of which 50 questions are not properly translated without producing an iota of material, your lordship can find fault with me. I discharge my initial burden to show these answers with these questions which is translated, it doesn't giving any meaning to a poor student like a graduate in BSc or BA. They are also entitled to choose for Kannada medium in writing the KAS examination. It is only the not law graduates. As a law graduate, I could be able to know who are the having the judicial review power. Can a BSc student can know that?
See, we can't answer on that.
I can't.
See, I just want to know from KPSC.
basic
Did
principle
your
and
expert, just,
and foundation of argument.
just a minute, I'll hear you. I just want to ask KPSC. KPSC, can you tell us whether your expert committee looked into this grievance or translation?
Please, my lords, even with regard to ambiguity in the questions also has been looked into. I will point out, my lords. We will place on record the report, my lords, that will show it even
Reply
that.
what we read just now, it was not mentioned.
Please.
Thank you.
Calling upon me to argue keeping in mind thought about the stand of the PSC. How can I know?
No,
Can I explain any justice to my
no.
advocate and
No, I'm sorry if you feel it like this. I just wanted, because you said I can't answer, so I asked. Just,
correct.
I just wanted to know one to answer, because see, in your record, you just now read that the KPSC reply which you just now read, in that there is no mention about whether the expert committee looked into the Kannada translation
Correct.
part. That's why I asked.
I will only point out page number 3 of my reply. I don't know how much more you will have to written. I'm sorry. Page number 3. Para B and A. The KPSC constituted 12 subject expert committees, and each committee consists of 3 subject experts having technical knowledge of both the languages Kannada and English. Now, beyond this, Lord, I don't know what we have to say that we have considered the Kannada language translation.
Here again,
They
they say,
examined and one
to
question, but
examine the correctness of answer keys and not the question
ಅದೇ
itself.
only next question ಒಂದು ಓದಿದ್ರೆ clarify ಸಿಗುತ್ತೆ.
See, why I asked this, because of the, just now applicants have given a judgment of Supreme Court of India. Para 12, in Kanpur University case, court recommended a system of moderation, avoiding ambiguity in the questions, and prompt decision to be taken, exclude suspected question. That's why I wanted to. That is what I wanted to know, whether KPSC has looked into these aspects.
Lords, we have, my lords, we have looked into. I have seen the expert report, my lords. We will point out.
They can trace the record before your lordship.
Well, expert report now.
We will close our argument. We will compliment the PSC. What transparent PSC, we will compliment. We will make good to.
Allah, our argument man ಮುಗಿಸ್ಕೊಳ್ಳಿ. In reply, you can argue all that in reply.
ನಾನು ಏನಾಗಿದೆ ಎಣ್ಣೆನ ನೀರಲ್ಲಿ ನಿಲ್ಸಿ ಇಷ್ಟು ಹಾಲು ಕೊಡುತ್ತೆ ಅಂತ how can I assume that? ಈಗ ಎಣ್ಣೆನ ಹೊರಗಡೆ ನಿಲ್ಸಿ ಹಾಲು ತೆಗೆದು 10 ಲೀಟರ್ ಕೊಡುತ್ತೆ I can understand. ಎಣ್ಣೆ ನೀರಲ್ಲಿ ನಿಲ್ಸ್ಬಿಟ್ಟು ನೋಡಿ ಎಷ್ಟು ದಪ್ಪ ಇದೆ ನಿಮ್ ತರನೇ ಇದೆ ಇದಕ್ಕೆ 25 ಲೀಟರ್ ಕೊಡುತ್ತೆ ಅಂತ can I proceed further? I'm sorry. Really, it's a wonderful argument.
No. This is just a dialectic.
Always.
Let him argue and finish the arguments. We will reply, my lords. We are just responding to a court query. We have responded to the court query. We cannot keep responding. My lords, it is not. First, we have to argue. Then, my lords, first they have to argue. We have to reply. Then he has the right of reply, rejoinder. No, he doesn't want to argue. The entire modus operandi, not the modus operandi, my lords. And my lords, regarding the submission that took place in the previous rounds of hearing, they made an incorrect submission. I will point out that.
Para 31 of the judgment which I cited, may kindly see.
Para number?
Para 31, that is.
You only 14 up to
People
14.
for the judgment, UPSC through Chaiman case.
Only para.
There are
Only
only appeal.
No, the
16
judgment of the Supreme Court is extracted at page para 11.
parallel.
Ram Vijay Singh's case, paragraph 31, 32 is extracted, which I wanted to read.
Yes.
On our part, we may add that sympathy or compassion does not play any role in the matter of directing or not directing re-evaluation of an answer sheet. If an error is committed by the examining authorities, complete body of the candidate suffers. Well, this is the gravity of examination. I can take what is the importance of written state referring to 86 Supreme Court, I will come later. The entire examination process does not deserve to be detailed only because some candidates are disappointed or dissatisfied or perceive some injustice having been caused to them by an erroneous question and an erroneous answer. All the candidates suffer equally, though some might suffer more, but cannot be helped since mathematical precision is not always possible. This court has shown one way out of an intake or exclude the suspect of the offending questions. Next paragraph may kindly read. It is rather unfortunate that despite several decisions of this court, some of which have been discussed above, there is an interference by the courts in the result of examinations. This places of examination authority in an unenviable position where they are number scrutiny and not the candidate. Additionally, a massive and sometimes prolonged examination exercises concludes with an air of uncertainty. While there is no doubt that the candidate put in a tremendous effort in preparing for an examination, it must not be forgotten that even the examination authorities put in equally great efforts successfully conduct an examination. The enormity of the task might reveal some lapse at a larger scale, but the court must consider internal clerk and the balances put in place by the examination authority before interfering with the effort put in the candidates who have successfully participated in the examination and examination authorities. The present appeals are and the examination and the example of consequences such an interference where there is no finality to result, etc. This is when I look at the importance of written examinations. That's what I said. We are not conducting the matter related to 7th standard public examination. I said so. May kindly look at these segment. What is the necessity of the written test? What is the importance? If the PSC or examining body could not be able to notice the gravity of this subject, then who else will know? Who else? Well, article 90 go to Para 3, 1986 one SCC page 671. Para 3, I don't want to read. Well, I just extracted question from Bhagavati's in Hajayasya's case at the very same page, it is in the word letter Majidali data or Can I know?
Yes.
The oral interview test is undoubtedly not a very satisfactory test for asserting, evaluating the capacity and caliber of the candidates. In the absence of any better test for measuring the personal characteristics and traits, oral interview test must at the present state be regarded as not irrational or irrelevant, though it is subjective, based on first impression. Its result is influenced by many uncertain factors and it is capable of abuse. We would, however, like to point out in the matter of admissions of a college or even the matter of a public employment, oral interview test is presently held should not be relied upon as an exclusive test, but it may be restored to only the additional and supplementary test, etc. Then go to the written examination as extracted Ashok Kumar's case. Next page, next para itself, middle of the question. The object of any process selection for entire entry into a public service is to secure the best and the most suitable person for job awarding patronage and favoritism. Selection based on merit tested impartially, objectively is the essential foundation and useful and efficient public service. Open competitive examination has come to be accepted almost universally as the gateway of public service. How should competitive examination be devised? This is the heading. This is the question answered by the Supreme Court. It is now well known, recognized that a written examinations assess a candidate's knowledge, intellectual ability. Interview test is only a visual assess a candidate's overall intellectual and personal qualities. Written examination has certain distinct advantages over the interview test. There are yet no written tests which can evaluate a candidate's initiative, alertness, resourcefulness, dependableness, cooperativeness, capacity for the clear and logical presentation, effectiveness in discussion, effectiveness in to make a decision, ability to lead, intellectual and moral integrity. Some of these qualities may be evaluated, perhaps with some degree of error by an interview test, depending on the constitutional interview board. This is the importance. We put this question when it ಕನ್ನಡದಲ್ಲಿ ಅರ್ಥ ಆಗದೆ ಹೋದ್ರೆ ಇಷ್ಟೊಂದು ನೀವು ನನ್ನಿಂದ ಹೆಂಗೆ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೀರಿ? ನಾಳೆ if I become an assistant commissioner, then I possess these requisite qualifications to meet the public. This is not our complaint. ಈ ಕಂಪ್ಲೇಂಟ್ ನ ಹೇಗೆ ಉತ್ತರ ಕೊಡಬೇಕಾಗಿತ್ತು ನಾನು ಅವರಿಗೆ ಅಡ್ವೈಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಒಬ್ಬ ಸಾಮಾನ್ಯ ಮನುಷ್ಯ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡೋದು ಹಿಂಗೆ ನೋಡಿ, ನಾವು 228 ಕ್ವಶನ್ ಕೊಟ್ಟಿದ್ದೀವಿ, 228 ಕ್ವಶನ್ ಕನ್ನಡದಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ದೀವಿ. ಈಗ ನಾವು ಇಂಥ ಎಕ್ಸ್ಪರ್ಟ್ ಹತ್ರ ಹೊಸದಾಗಿ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಬಿಟ್ಟು ಕ್ವಶನ್ ಮಾಡ್ತಿದ್ದೀವಿ. ತಗೊಳ್ಳಿ, ನೀವು ಕೊಟ್ಟಿರೋದಕ್ಕೂ ನಾವು ಇಷ್ಟು ವ್ಯತ್ಯಾಸ ಇದೆ. therefore we are right ಅಂತ ಡಿಫೆಂಡ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಏಜೆನ್ಸಿಗೆ ಏನ್ ಕಷ್ಟ? ನಾನು ಯಾರೋ ಲೆಕ್ಚರರ್.
And everything, my lords, is a dilatory tactic. Every kindly note, my lords, every pitch he makes, he wants an adjournment, and he wants us to refer, and that is only for the sake of adjournment. This is, my lords, and he is making comments against the commission, my lords. We know how to defend our cases. We will defend our cases. Let him argue his case. Will my turn come, my lords, before he completes? If my lords ask me a query, I will respond to that. Otherwise, let him finish his argument, or say I will reserve everything for rejoinder. I will reply right now. I will start my argument.
I need not give any liberty for them. I have argued 100 things. They are going to respond for each and every one. I need not welcome for that. If it is not happy, your lordship say no. If your lordship is happy, your lordship say no to me. That is the judicial proceeding. I may not know that as a senior counsel.
215 ಅವ್ರಿಗೂ ಸಾರಿ the tempers are high. I think it's
Okay,
better.
Baba, somebody from Hungary to come.
230 will continue.
My lords, tomorrow, my lords, will continue. My lords, I will come to the court. I will get the record. I will give it to the court. If my lords want to share it with them, let them have to get it. ನಾಳೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸ್ವಾಮಿ ನಮ್ಗೆ.
Tomorrow you can continue. Up to 2:30 you continue. Sir, the letter will adjourn it tomorrow.
2:30 till 2:30.
ಅಲ್ಲ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ, remaining matters.
Instead of allowing them to
ಅಲ್ಲ, I request my lordships to what will happen to the remaining matters. 2:30 ನಾವು ಬೆಳಗ್ಗೆಯಿಂದ ಕಾಯ್ತಾ ಇದೀವಿ. 2:30 ಮತ್ತೆ ಹೈಕೋರ್ಟ್, ಅದಕ್ಕೋಸ್ಕರ ಇವನ್ ತಿಂಡಿ ತಿಂದಿಲ್ಲ ಕಾಯ್ತಾ ಇದೀವಿ.
ನಾನು 11 ಗಂಟೆಗೆ
ನಾವು MP ಪ್ರಕಾಶ ಒಂದ್
ಅಲ್ಲ,
ಸ್ವಲ್ಪ
KM ಪ್ರಕಾಶ್ ಸ್ವಾಮಿ
ಒಂದ್ ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ನಾವೇನ್
ಅರ್ಥ ಆಯ್ತು ಸ್ವಾಮಿ, ಎಲ್ಲ ಅರ್ಥ ಆಗ್ತಾ ಇದೆ, ಏನ್ ಆಗ್ತಿದೆ ಅಂತ ಹೇಳಿ
ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಸ್ ಅನ್ನ ತಗೊಳ್ತಾ ಇದ್ದೇವೆ. ನೀವು
ಅದಕ್ಕೆ ನನ್ನ ಮ್ಯಾಟರ್ ನಾಡಿದ್ದಕ್ಕೆ
ಏನ್ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕು, ಅವ್ರು ವೇಟ್ ಮಾಡಾಕ್ತಾರೆ, ಏನ್ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ ನಮ್ಮಿಂದ ಆನ್ಸರ್ ಕೇಳಿ ನಾವೇನ ಹೇಗೆ ಆನ್ಸರ್ ಮಾಡಕ್ಕಾಗೈತಿ?
ಅಲ್ಲ, ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಸ್ವಾಮಿ, ಹಾಗೋಸ್ಕರ ಅಷ್ಟೇ. ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ನಾಳೆ ಹಾಕೋಬೇಡಿ ಸ್ವಾಮಿ, ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕೋಬೇಡಿ.
ನಿಮ್ಗೆ ಯಾವ್ದಾದ್ರು ಕನ್ವೀನಿಯಂಟ್
ನಾಳೆ ಹಾಕಿ ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಯಾಕೆ ಹೇಳಿದ್ರೆ ತಾವು ನೋಡಿದ್ದೀರಾ 11 ಗಂಟೆಯಿಂದ.
ಇಲ್ಲ,
There are 6 matters I have been engaged. I requested all my briefing counsel to have this matter at 2:30. Out of 6 matters, 2 matters have been adjourned. Still 4 matters I have to argue after going to high. This is my risk.
tomorrow we'll take it.
Tomorrow.
KM ಪ್ರಕಾಶ್ ಡೇಟ್ ಕೊಟ್ಬಿಡು.
ನಾಡಿದ್ದಕ್ಕೆ ಸ್ವಾಮಿ 2 ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಮತ್ತೆ ಇದು ಕಂಟಿನ್ಯೂ ಆಕೈತಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು. ಯಾವತ್ತಾದ್ರೂ
ವೇಟ್ ಮಾಡುದು.
ಎನಿ ಅದರ್ ಡೇಟ್, ಬೋತ್ ಇನ್ 31 and 36. ಅಲ್ಲ, ಏನಿಲ್ಲ, ಸೀನಿಯರ್ ಯಾಕೋ ಬಹಳ ಸಿಟ್ ಮಾಡ್ಕೊಂಡ್ ಬಿಟ್ಟಿದ್ದಾರೆ, ಸ್ವಲ್ಪ ಕೂಲ್ ಆಗ್ಲಿ ಅಂತ ಅಷ್ಟೇ.
I make one request. Could it be taken up tomorrow at 12:30 so that by 2:30?
ಇಲ್ಲ, ಟೈಮ್ ಏನ್ ನೋಡಕ್ ಆಗುದಿಲ್ಲ. ಬಟ್ ಕರೆಕ್ಟ್ ಬೆಳಿಗ್ಗೆ ನೋಡೋಣ. ಕಾಲಿಂಗ್ ಮುಗಿದ ನಂತರ ಅನ್ನಿದಂತ priority will be given to this case because it is parted matter.
Very
We heard the heard Sri Rajgopal, learned senior counsel for the applicants in application number 285 to 308 of 2020-25. ಇದರಲ್ಲಿ ಒಂದರಲ್ಲೇ ತಯಾರಿಲ್ಲ ತಾವು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇದರಲ್ಲಿ ಒಂದರಲ್ಲೇ ಇನ್ನೊಂದು
285 one collected now.
kind connected application number 563 to 614 of 2025. And for further arguments, post this matter on L13 at 12 noon and at 12:30. Time in
My lords, we will come, my lords.
right basement it's upon.
Please, grateful, my lords.
Continue ಮಾಡಕ್ಕೆ continue.
ಯಾವ application number
ನಾಳೆ UPP had on 13th.
No.
ಅಲ್ಲ, ರೂಪನ್ ನಿಮ್ದಲ್ಲ. 35.
interim order granted earlier is extended till next date of hearing. First, right.
Grateful, my lords.